Good afternoon. My name is Lincoln Marr, and I am happy to welcome you to this session of the Office of the Public Guardian and Trustee Learning Series. For more information about this series of webcasts, you can check your emails for regular updates, or you can go to csslearningseries.ca, or you can also follow us on Twitter at AlbertaCSS. In today's session, I will be taking you through the process of completing an initial application by the desk process for guardianship and trusteeship under the Adult Guardianship and Trusteeship Act, or what I will subsequently refer to as the AGTA. An initial application is one of the most common applications that can be made under the legislation. There are other applications that can be made. Clearly, if you're already a trustee and or a guardian, there are review applications that can be made under the legislation, as well as applications by a trustee to have the trustee's accounts reviewed by the court. And all of these types of applications can also proceed via the hearing process, which means that the application is actually set down to be heard in a courtroom before a justice. I started working for the Office of the Public Trustee in 1990 as a trusteeship specialist. And then in 2010, I transferred over to the Office of the Public Guardian to assist in the implementation of the AGTA, which came into force in 2009. And currently, I am a trustee specialist and review officer with the now combined Office of the Public Guardian and Trustee, or what again I will subsequently refer to as the OPGT. There will be an opportunity to answer questions at the end of the presentation. So if you have any questions, you can type them into the chat, and they'll be collected, and we'll deal with them at the end. And again, thank you for attending, and here we go. So when contemplating trusteeship and guardianship, and I'm going to start right from the beginning, so the first question to ask is there an adult that you suspect has diminished capacity to make either personal decisions, such as where to live or healthcare decisions, or financial decisions? Now, that diminished capacity may be as a result of something that existed since birth, like someone who has a Down syndrome, or it could be something that the adult acquired, such as if they had a brain injury from a motor vehicle accident or a fall or something of that nature, or some kind of illness, such as Alzheimer's or dementia, something of that nature. So again, it could be something that's existed since birth, or it could be something that the adult has acquired, for want of a better word. And, as is pretty obvious, sometimes the diminished capacity of the adult is quite evident, and other times it isn't. Very often we have adults who are very high functioning and can function on very well on a day-to-day basis, but if it came to making, decisions like should they have a particular medical procedure or making investments, if let's say they were a beneficiary of an estate, then they wouldn't have the capacity to understand all the information that's required to take in and then make a appropriate and reasoned decision. So if the answer to decision one is yes, there is an adult who may have diminished capacity, then question number two is, can assistance be provided to that adult without going to the extent of obtaining a guardianship and or a trusteeship order under the AGTA? One of the principles of the AGTA is that the least intrusive method should be employed to assist the adult in their day-to-day living, both making personal decisions and financial decisions. So for personal matters, obviously, our office certainly encourages every able-bodied adult to make a personal directive, essentially a document that comes into effect if the maker becomes mentally incapacitated, and it appoints an individual or more than one individual, called an agent, to make personal decisions on behalf of the maker. Now, again, if every adult had that, then actually guardianship would probably be very, very seldomly used, because essentially a personal directive appoints the agent into a position very similar to what a guardian does under the legislation, and would allow that agent to make those kind of personal decisions. As well, if there's no personal directive, under the AGTA, there's also something called co-decision making. Now that is for individuals who have significantly impaired capacity but still have some capacity to understand and make decisions. So a co-decision making order is still an order of the court. There is still some medical evidence that needs to be provided. Unfortunately, the definition of significantly impaired hasn't really been solidified in the legislation or in the practical sense. And so co-decision making orders, while they exist and while there are some that have been obtained, they're not too, they don't happen too frequently, mostly because on the continuum of capacity, individuals who at the point in time that you're assessing them have significantly impaired capacity, likely sometime in the future, whether it be quite soon or a little bit longer, farther away, but eventually they are going to lack capacity totally to make decisions, at which time a guardianship order likely would be necessary. So most people, when they're looking at the situation, they would go, if necessary, goes directly to a guardianship order. There's also under the AGTA something called specific decision making. Now, specific decision making involves a health care provider having the belief that an adult lacks the capacity to make a decision regarding the adult health care or temporary admission to a residential facility. So this is a situation, it's quite specific to individuals usually who are in active treatment hospitals who either need a specific decision made about a particular medical procedure or a decision made about transitioning from the active treatment hospital to an outside residential care facility. In those situations, and again, there's a lot of rules and regulations in the legislation, the healthcare provider, essentially the doctor whose care the adult is under, can pick a person, usually it's a next of kin, sometimes it is the public guardian's office, to make that one-time specific decision either about healthcare or about temporary residence in a residential facility. For financial decisions, the equivalent of a personal directive is an enduring power of attorney. Again, it's a document that the donor, in this case that's what they're called, who's fully competent, they can appoint one or more persons as their attorney to make financial decisions on the maker's behalf if the maker becomes incompetent to make those financial decisions on his or her own. And again, if everyone had an enduring power of attorney, then trusteeship orders wouldn't be as frequently obtained as they are now, because again, an attorney under an appropriately written enduring power of attorney essentially has most, if not all, of the authorities that a trustee would have appointed under the AGTA. And of course, for financial decisions, there are a multitude of informal trusteeship methods that are available. I always say from the very simple, such as having a joint account. So for example, if I had a joint account with my mother and all of her pensions, all of her income, everything flowed into that account, and so I was able to access it and pay all of her bills, and there were no other assets that existed that I had to deal with, then potentially I could get along with just having a joint account with my mother and informally assist her in managing her affairs, even when she was not capable of doing so. However, also most of the government benefit programs have their own informal trusteeship process. So for AISH or Canada Pension Plan or Old Age Security, all of those government pension programs have their own process whereby a third party can apply to the benefit program, so apply to AISH or apply to CPP, to be appointed as an administrator of the individual's benefit from that program. So again, it doesn't extend past that program. So if it's a senior and they're collecting both CPP and Old Age Security, you have to apply, you have to follow the process for each of those benefit programs to essentially become, to receive the authority to deal with the adult's benefit from that benefit source. Now that doesn't extend to if the individual adult had other assets, such as if they owned land, if they had private pensions, if they had money in a bank account that no one can access except for the adult, then most of the informal trusteeship methods don't work because, again, a bank isn't going to recognize that you are the financial administrator for an individual's AISH to allow you to access your bank account. Private pension that you're getting from perhaps a private employer isn't going to recognize any other kind of piece of paper, just the fact that you've been appointed as a financial administrator for some other program, some other benefit, isn't going to normally carry through to whatever private pension the adult is receiving. So again, informal trusteeship, depending on the circumstances, might be enough to manage the adult's financial affairs, but if there are assets or if there are situations where the informally isn't going to be sufficient and that the authority of a trusteeship order is needed, then you're going to have to kind of move on and say, no, informal isn't going to work. I'm going to have to go the formal route of getting a trusteeship order. So if now the adult has diminished capacity, yes, informal methods aren't going to work. So decision number 3 is, okay, if a guardianship and or a trusteeship order is required, can you, as the applicant, prepare the application documents yourself, or do you need to retain a lawyer to assist you? Right? Now, under the AGTA, part of the process in revamping the legislation back in 2009 was that one of the key features was to make the process more user-friendly and more available to the public than the previous process under the Dependent Adults Act. So now all of the application documents are available online on the OPGT's website. The documents can actually be completed online and then printed for signing. The online documents, and we have continued to make improvements since they first existed in 2009 and 2010. So now there are a lot of fields on the online documents that if you fill in the field once, so for example, if you put in the adult's name on the page 1 of the application, then everywhere where the adult's name appears, that name will appear. It cuts down severely on any of those kinds of transcription errors or errors where some places you put the adult's middle name, some places you didn't put the adult's middle name. We found that that's very helpful because when we submit the applications to court, the court is looking for those little discrepancies that, again, on a court file that are not acceptable, and so those applications were getting rejected. So we've tried to improve the online process, particularly to eliminate those kinds of minor but bothersome errors. As well, there are various agencies that our office has contracted with across the province to assist individuals in preparing applications under the AGTA, and there will be a list of our regional offices and phone numbers at the end of the presentation. So if you need the contact information for an agency that's in your vicinity, please call our office. There's a number of them, and they do change, and contact information does change, so the best way to find out what's the current information is to contact one of our offices. If it is anticipated that the application will be contested in some way, either by the adult or by some other interested party. So for example, if you are applying to be guardian and trustee for an individual, and perhaps there's another sibling, another individual, who knows, who thinks that they would be the more appropriate trustee and guardian, then perhaps there might be a conflict, a contest as to who would be the most appropriate guardian and trustee for the adult. So in a situation where it's anticipated that there will be a conflict or a contest, if you will, it may be advisable, A, to hire a lawyer right at the beginning so that you kind of have a lawyer on board to understand the process right from the beginning and understand the situation. And B, it may be advisable to consider whether the application should proceed directly through the hearing process, which is, again, most of the same documents have to be completed. Actually, there's just a few additional ones that are completed. But essentially, the application is, right from the beginning, set down for a hearing in a courtroom before a justice, and all the people who might have objections would get notice of that application, so they know if they have something to say, some information they want a justice to hear, that they would appear on that date and hopefully get the application heard and determined at that time. This obviously saves trouble because the DES procedure, and I'll go through it in more detail later on, the DES procedure is you submit the application documents to our office, we send out notice of the application to all the required parties who have a certain period of time to either say, I'm okay with the application, or return a request for hearing to our office. If a request for hearing is returned to us as part of the desk process, then we still file the desk application with the court, but then the application doesn't get read or reviewed by justice. Then the applicant, at that point, once the application has been filed with the court, has to set the matter down for a hearing before a judge to be heard in open court. So again, if it is suspected that someone will object, then our recommendation very often is to go directly to a hearing. So, as part of the application process, the medical evidence that the court will use to determine if the adult lacks the capacity to make personal decisions or financial decisions, or both, is called the Capacity Assessment Report, or CAR. And that a CAR is a regulated document, so there isn't a lot of different formats of that. It's a regulated document that can be found in the regulations to the AGTA. The CAR can be completed by either a physician, a psychologist, or one of the designated capacity assessors. Designated capacity assessors have to belong to one of the health professions set out in the regulations, and as well a designated capacity assessor has to undergo training sessions provided by our office and has to kind of undergo ongoing reviews and competency assessments and so on. There is a regulated maximum fee in the legislation of $500 that a capacity assessor, whether it be a physician or a psychologist or a designated capacity assessor, can charge if the capacity assessment is for either trusteeship or guardianship, and a maximum fee of $700 if the assessment is for both guardianship and trusteeship. Now, a court can, on application by an applicant, or increase that fee due to the complexity of the assessment, but to be honest, we have seen a variety of fees charged by capacity assessors, from nothing to sometimes the max, and sometimes more, again, depending on the situation. So when you're getting a capacity assessment done by the adult's physician or psychologist, or potentially you might be contacting a designated capacity assessor to do an assessment, certainly you should be asking about what the fee will be. The CAR, because it is kind of that one piece of information that a court will depend on to determine the capacity of the adult, all of the sections of the CAR should be completed, even if it kind of appears that they don't apply. So then, potentially not applicable, or NA, should be entered into those sections by the assessor. There is provision in the AGTA for a court to determine capacity of an adult without a capacity assessment. But in that case, and it's fairly rare as far as I know, the court would have to be provided with other evidence of the adult's incapacity. And this is where I always say, and that other evidence usually can't just be their strange behavior or something of that nature, because I've been in this business since 1990, and one of our mantras always is, just because someone acts unusual or what we would consider abnormal or out of the ordinary, certainly does not, that in and of itself does not mean that their capacity is at issue in any way. So once the CAR is completed, the CAR, along with all of the other application documents, must be submitted to our office within 6 months of the date of the CAR. There's a section of the legislation that indicates, because of course they want the medical information to be fairly recent when they're making a determination of capacity. Again, depending on what the capacity assessment says, so for example, if the assessment was about someone who had Down syndrome, so a condition that's not likely to improve and potentially could get worse, so again, the capacity of the adult is not likely to change, then an applicant can ask the court to accept a capacity assessment report that is outside that 6-month window. And again, it's up to the court to determine if yes, they'll accept it based on the information and the indicated condition of the adult, or no, the court may say, no, I want you to get an updated assessment before we proceed with the application. So once you have the CAR completed, then it's time to kind of collect all the information needed to complete the application documents. I always think this part is, well, I guess it's the way I do it. It's the way that I do my taxes, right? Before I sit down and open my tax software, I collect all my T4s and all my slips and everything so that when I'm actually doing the application documents, I have all the information in front of me. So kind of the main information that you're going to need to collect to do an application is firstly, and kind of most importantly, the full name, including any middle name of the adult. Now, this is important because that is the name that goes both on the court file and will appear on the court order. And so, of course, if you're giving that court order to a care facility, or particularly if it's trusteeship, if you're providing that court order to a financial institution or to the Canada Revenue Agency or something of that nature, they're going to look to make sure that the court order clearly is about their client, whether it be the CRA or the financial institution or anything of that nature. So if you don't have their full name, then that could lead to problems. As well, you should consider putting as aliases in the application any names that the adult is well known by. So there's some people who maybe always have gone by their middle name, right? But they actually have a first name that they never go by. As well, if there are names that aren't their full name that the adult has assets in. So again, there have been situations where people have had property registered at land titles by only, I don't want to say a nickname, but either a short name or a kind of a different name. Then you want to potentially include all of those names on the court order so that you don't have any problems later on when you're trying to deal with all of the affairs of the adult by someone saying, oh no, it's not clear that this court order applies to this person or this piece of land or something of that nature. You will want to, of course, have the address of the adult, both the permanent address and potentially their present address if it's different from the permanent address, including the full mailing address of any residential facility in which the adult resides. That is because part of the legislation indicates that the director of a residential facility in which the adult resides receives notice that the application is being made. Under the AGTA, one of the new provisions, unlike under our old legislation, is that a number of next of kin of the adult receive notice that an application is being made under the Adult Guardianship and Trusteeship Act. So those individuals are family members residing in Canada who fall into any of the following categories. Spouse or adult interdependent partner. Most persons only have one or the other of those, but there are some people who have both, so it would include both. Living parents, obviously, who reside in Canada. Children 18 years of age or older, and siblings 18 years of age. Now, so you as an applicant, you need to collect all that information, if possible, the names and mailing addresses of all of those people in those categories residing in Alberta. As well, you want to have the names and addresses of any other interested parties who you feel should receive notice of the application. So sometimes we've certainly seen neighbors and friends and agencies that have been working with the adult. Essentially as an applicant, you can indicate whoever you feel should get notice that the application is being made under the AGTA. So again, once you've now completed all that information, then it's time to kind of complete the application. And so I'm not going to go through every section of the application form, and clearly I don't have it. I'm not going to go through it page by page, but I'm just going to hit some hints and tips for completing the application so that your likelihood of having a complete application that isn't rejected by us or there's no problems is higher. So the first document that needs to be completed is the application form, or the Form 14. So in completing the guardianship section of that form, the personal matters that are checked off on that form should match the areas that are checked off in the capacity assessment report. So when you look at the capacity assessment report, in regards to the personal matters that the adult does not have capacity to make decisions about, there are a number of categories: healthcare decisions, living arrangement decisions, vocation like employment, studying, a number of different categories. So on the capacity assessment report, what the assessor is supposed to do is first know what areas they're supposed to be assessing for, assess in those areas, and then check off either yes, the adult has capacity in these areas, or no, the adult doesn't have capacity in these areas. So on the areas in the capacity assessment report or CAR where the assessor has indicated that the adult lacks capacity, then essentially those are the only areas that on the application the proposed guardian should be asking for authority in. Now, as a proposed guardian, you can ask for less authority than is indicated in the capacity assessment report. For example, I always think the biggest example is if in the CAR the assessors indicated that the adult doesn't have capacity to make decisions about employment, but if the adult is in fact a 85-year-old retired individual living in a care facility, then employment is not likely going to be an issue. And so if you don't ask for that authority in the application, it's probably not going to be any kind of problem. But normally you shouldn't be asking for more authority in the application than is indicated in the capacity assessment report, because essentially the assessment report which will indicate that the adult does have capacity in those areas. If two or more guardians are applying to be appointed at the same time, then unless the court directs otherwise, each guardian can make decisions separately in all the areas of guardianship authority. So essentially, if there's two guardians appointed, then either one of them could give permission to have a medical procedure done, could make a decision about where the individual is going to live, and so on. In the trusteeship section of the application form, the first section is about trusteeship special authority. Now, under the legislation, a trustee, when appointed without any other information in the or special authority or conditions in the order, a trustee essentially has authority to manage all of the adult's financial affairs, with a few exceptions and conditions. So, one of those exceptions or conditions is that if the adult will have independent access to a bank account in the community, then that section of the application and that corresponding paragraph needs to appear in the court order. And the reason for that is that when a trusteeship order is granted, it actually changes the legal status of the adult from a competent individual like you or I to someone who does not have the capacity to contract and make legal decisions. And the ability to contract includes the ability to operate a bank account. So what the bank wants is they want to see that the trustee has authority to allow the adult to independently operate that bank account. Otherwise, as many financial institutions have requested, some insisted, the trustee has to be present every time the adult is there to take out $10. As well, a trustee is restricted in what they can do with real property in regards to selling it or leasing it for a term longer than 3 years and so on. So if the adult does own real property and if it is anticipated that the property is going to be sold soon or at some point, then the applicant has to consider if they should be asking for that authority to sell property on that initial application or potentially on a subsequent application. My advice to trustees usually is, if you're not sure when it's going to be sold, so you don't really have any details, you're not sure what the value is, you're not sure when it's going to be sold, you're not sure what it's going to be sold for, then we have seen that the courts have been reluctant to give a trustee blanket authority to sell, just to say, okay, yes, you can sell the property, so that means they could sell it for $1 to their neighbor or anything of that nature. So the courts usually like to have more details about the sale before they'll grant that kind of authority. And then, we have seen the courts even put different restrictions on the sale, such as it has to be sold within a certain price range and so on and so forth. As well, one of the new things under the legislation, the AGTA now allows individuals who are not resident in Alberta to apply to be trustee or alternate trustee for the adult. That's a change from our old legislation where trustees had to be resident in Alberta. So the offset to that is that if you are a non-resident proposed trustee or proposed alternate trustee, then the legislation says that you have to provide a bond, which is kind of like an insurance policy, or some other kind of security before you get appointed as trustee or alternate trustee, unless the court dispenses with that requirement, the bonding requirement. So I will say in 99.5% of the applications that we receive where there are non-resident trustees or alternate trustees, the court is being asked to dispense with the bonding requirement, but it is something that as an applicant you have to be aware of because you have to ask for it in the application itself. The court, if the court isn't asked to dispense with it, then the legislation says the court has to put some kind of bonding requirements or bonding conditions in the court order. If there are more than 2 trustees appointed for an individual, then subject to the court directing otherwise, all of the trustees have to act jointly. So that means they have to make all decisions together. So if they're going to renew an investment, all of the trustees have to sign and so on. So you'll notice, if you recall what I said previously about guardians, the kind of default situation is opposite from guardians and trustees. 2 or more guardians usually can act separately unless the court directs otherwise. 2 or more trustees must act jointly unless the court directs otherwise. Another thing that's new under our AGTA is that for both guardianship and trusteeship, an applicant can ask the court not to require a review of the guardianship or trusteeship order within a certain period of time. Under the old legislation, you had to have a review date, whether that be 6 years from the date of the order or 12 years or whatever, but there had to be a set time at which the trustee or guardian had to do a review of the order. Under the new legislation, essentially, depending on the situation, an applicant can ask the court not to set a future review date. Generally, that decision is based on the capacity assessment report, because if the adult's condition will not change, so the adult is not likely to regain any kind of capacity, then the court is more likely to say, no, I don't need a review, because there's already provision under the legislation that if a trustee or guardian no longer wants to act as trustee or guardian, they have to come back and do a review application. So the purposes for the review generally usually are, does the adult still require a trustee and guardian? And if the CAR says their capacity isn't going to improve, that question has been answered at the beginning. And number 2, if either the trustees and guardians don't want to continue or they want to change the people who have been appointed as trustees and guardians and so on, then the legislation says you got to come back and make a review anyway. So just having a review for the sake of a review can now be done away with. And it's very possible that an individual gets appointed as guardian and trustee for an adult and never has to come back to court to do a review of their trusteeship and guardianship order. In the capacity assessment report, there is a section that indicates that where the capacity assessor indicates if giving notice to the adult of the application being made would cause serious emotional or physical harm to the adult. If the capacity assessor indicates that a notice would cause serious physical or emotional harm to the adult, then the applicant should be requesting that notice of the application being made be dispensed with to the adult. Because again, normally, if that isn't a problem, the adult gets notice of the application. I'll discuss that a little bit later, as well as a number of other people. But if that notice would cause harm to the adult, either physically or emotionally, then the applicant should be asking that that notice be dispensed with. It is also possible, even if the capacity assessment report indicates that there would be no harm, that the applicant may feel that that notice would cause harm either physically or emotionally to the adult. And in that case, then the applicant can still ask to have the service dispensed with on the adult, but then they would have to put reasons in the affidavit why they feel that that harm would exist, because the capacity assessment report doesn't have any reasons. Okay. So in the affidavit, so the next document is the affidavit. So this is the document sworn by the applicant that sets out essentially the reasons why it would be appropriate for the court to appoint a guardian and or a trustee, and in fact the proposed guardians and trustees for the adult. Obviously, all the questions in the sections that apply to the application being made should be completed. As I've previously mentioned, if the applicant is asking the court to dispense with notice of the application to any of the other required parties, so as I previously said, you know, all the children and all the brothers and sisters of the adult get notice of the application. So as an applicant, if you don't want one or more of those brothers and sisters to get notice, potentially it might be for any number of reasons. It might be as simple as you just don't have their address. So this is where you would have to say, I want to dispense with notice to those individuals simply because I don't know where they are. So you have to set that out in the affidavit. As well, in the affidavit, an applicant should indicate or should provide any additional information that would be useful to the court in making a determination of whether to grant a trustee any special authority or special direction, such as authority to sell real property or a request to dispense with the bonding requirement. If the application includes a guardianship, a request for guardianship, then a guardianship plan, Form 32, needs to be completed. So these are both kind of new to the AGTA, and essentially both the guardianship plan and the trusteeship plan that I'll talk about in a second, they're both documents that allow the court to ensure to a certain extent that the proposed guardians and alternate guardians and trustees and alternate trustees have actually thought about what decisions they will have to make for the adult if they're appointed in those positions. So they've thought about, you know, is the person going to have to, are there medical decisions that are kind of imminent? Is the person going to have to move from their home into some kind of care facility? And, you know, are those decisions that the guardian is going to have to make? The guardianship plan, it needs to be signed by all of the proposed guardians and all of the proposed alternate guardians. If the application includes trusteeship, then a trusteeship plan, Form 34, needs to be completed. And again, that's because the court wants to know that the proposed trustees have thought about how they are going to manage the financial affairs of the adult. The applicant, or proposed trustee in this case, should try to provide as much information as possible about the assets and liabilities of the adult. There are worksheets that form part of the trusteeship plan that can be used by the applicant to determine what the income and expenses of the adult are. However, those worksheets don't have to be used, but if they're not used, they should still be, the blank worksheet pages should still be included in the application form, mainly because they throw all the numbering of the pages off. Some paragraphs in the trusteeship plan correspond to paragraphs in the application, the Form 14. So obviously the answers to those questions in the application and in the trusteeship plan should be consistent. As well, in the trusteeship plan, usually there's more room to elaborate on those answers. So if there's any other reasons or any other information that should be given to the court to help them make the determination that this would be in the best interest of the adult, then that information should be provided in the trusteeship plan. As I previously mentioned about non-resident trustees and alternate trustees, there's a section in the trusteeship plan that very specifically asks for the reasons why it would be in the best interest of the adult for the court to dispense with the bonding requirement. And again, this is where an applicant can elaborate a little bit more and provide whatever reasons they feel will allow the court to make the decision that the bonding isn't required. The bonding requirement can be waived for those out-of-province individuals. And only proposed trustees have to complete and sign, or only proposed trustees have to sign the trusteeship plan. If trusteeship is part of the application, then an inventory form needs to be completed. And essentially, I always say the inventory form, it's a sworn document, and it is a snapshot of the adult's financial affairs as of a certain date. The date is set out on the first page of the document. And so it's essentially what that adult's financial picture looks like on that date. The inventory can be completed and submitted with the initial application, or the applicant or the trustee can undertake to file an inventory with the court within 6 months of being appointed as the trustee. So sometimes the situation is that an applicant or a proposed trustee isn't quite sure what assets and liabilities the adult has. And so it might be more beneficial to undertake to file that inventory later on once the trustee has been appointed and has the authority to kind of do that investigation to find out more accurately what the adult has in their estate. Because the inventory essentially, once it's filed, that gives the starting point for what the trustee is managing on behalf of the adult. So the more accurate information that can be contained in that inventory document, the better. Every trustee that's named on the first page, now ideally every proposed trustee should be named on the first page of the inventory document and should sign and swear or affirm the inventory document before a commissioner for O's. However, if only one of a number or if not all of the trustees are available, so only one of them or one of a number of them are named on the first page, then only those individuals should swear the document. The inventory contains schedules for income and expenses that need to be completed if the adult has income and expenses, and the information contained in those schedules should correspond with whatever income and expense information is provided in the trusteeship plan. And for certain assets like real property or bank accounts or investment accounts, copies of the certificate of titles to those pieces of property and current account statements are requested to be attached to the inventory to confirm the amounts that have been reported in the inventory document. And because the inventory is a sworn document, then those attached statements need to be properly marked as exhibits to the inventory and need to be commissioned by the Commissioner for O's. So one of the last things that needs to be provided as part of the application is consent. So every proposed guardian and alternate guardian, trustee and alternate trustee must complete and provide with the application a consent form. And on all of those consent forms, it does ask you if you have a conflict of interest with the adult. And one of the things I will always want to say, I always tell everyone, is that it's not a conflict of interest in and of itself if a proposed guardian or alternate trustee or alternate trustee is or may be a beneficiary of the adult estate upon the death of the adult. Because of course that would eliminate any spouse becoming trustee or guardian for their spouse, or any child becoming trustee or guardian for their adult, for their parents, or even the other way around, right? So just being a beneficiary of the estate of the adult, in just that alone is not a conflict of interest. A conflict of interest usually is an actual thing that everyone would go, oh yes, you shouldn't be the trustee, you shouldn't be the guardian. In addition to the regulated consent forms, as previously listed, there are also consent forms that need to be completed from the agency that we contract with to complete the suitability checks for each proposed guardian, trustee, and alternate trustee. Right now that company is called BackCheck, and so in addition to the regulated consent forms, there would be BackCheck consent forms that need to be obtained from our office, completed, I believe they have to be sworn before a commissioner for oaths or a notary public, and then returned to our office. And those consent forms are giving consent to back check, as requested by us, to complete for guardianship a criminal records check and 2 reference checks for a proposed guardian or alternate guardian, and for a proposed trustee or alternate trustee, it would involve a credit check and the criminal check and the 2 reference checks. So again, those additional consent forms also have to form part of the application. So once you have all that information together, you have the application documents, you have the original CAR, you have all the suitability screening consent forms, you have the regulated consent forms, and you have the court filing fee of $250. All of that information is submitted to our office, the regional office in your area. So once we get the documents, we look all the documents over to confirm if they are, to see if there's any concerns or errors, missing documents, missing signatures, or any other problems with the application that would cause it to be rejected by the court for filing. So if there are any problems of that nature, we will contact the applicant and work with the applicant to correct any of those errors. Once that application is complete in our eyes, then 2 things happen. 1, our office sends notice of the application to all the parties required to receive notice under the legislation. So again, subject to any requests to dispense with notice on a party, the adult gets notice, all of those next of kin that are listed in the application get notice, the director of the residential facility, if there is one, gets notice. So all of those individuals get notice of the application. And unless the applicant has asked that service or notice to the adult be dispensed with, one of our review officers will actually go out to visit the adult, provide them with a copy of the application document that they are to receive, will, to the extent possible, explain the nature and purpose of the application being made, and again, will ascertain, to the extent possible, the views and wishes of the adult respecting the application. So every adult on every application, again, unless the notice is asked to be dispensed with, will get a visit from our office or an agency contracted by our office to find out if, how they feel about the application. So again, as I mentioned earlier, the only reason to dispense with notice is if there is harm, there's potential harm to the adult. So just because the adult wouldn't understand the documents or something of that nature, in the opinion of the applicant, is not reason for notice to be dispensed with. So our office goes out all the time to individuals, to see individuals, and again, to a certain extent, to confirm that yes, either they can understand to whatever extent possible, in which case we will explain to whatever extent possible what the application is about, or we will confirm that no, the individual doesn't understand what the application is about, and we'll report that back to the court. So everyone who receives notice of the application, including the adult, has the right to submit a request for hearing to our office. If a request for hearing is submitted, we still file the application with the court, but again, the application won't proceed until the applicant sets a hearing before a justice for the application to be heard. Once all the notices have gone out and there's a legislated waiting period that we have to wait, if no request for hearing, or once the notice period has passed, whether or not we received a request for hearing or not, then the review officer will complete a review officer's report, which summarizes the application process. It indicates who did or did not receive notice of the application. It indicates the result of the suitability screening checks. It sets out the views and wishes of the adult in respect of the application and advises if a request for hearing was submitted. So again, it's a summary report of the entire application process. So the review officer's report and the application documents will all be submitted to the court for, hopefully, again, if there is no request for hearing, they will be submitted to the court. Hopefully the court will file the documents, they won't find any mistakes or anything of that nature, and eventually a justice will review the documents and determine if the application should be granted or not. If the court has any questions about the application, they will normally contact our office, and we in turn will contact the applicant to obtain the information and figure out the best way to get that information back to the court. Part of the application process is when we send the application to court, we also include stamped, addressed envelopes addressed to all of the persons who received notice of the application, so that if the trusteeship and guardianship order is granted, then the court will send out a copy of the granted order in those envelopes that we've provided to all of those parties. So this is a list of the regional OPGT offices and the phone numbers. Like I said, certainly call our offices if you want the contact information for any of those agencies that assist individuals in completing AGTA applications. As well, I really encourage individuals who are contemplating trusteeship and or guardianship orders, or potentially applying for trusteeship and guardianship for an individual, if they have any questions, to contact our office. We are happy to discuss situations with you, discuss options, go through different situations with you, and provide applicants and provide concerned individuals with as much information as we can about the process, and to help individuals make the best decision possible in the interests of the adult in regards to guardianship and trusteeship. And that is the end. Do we have any questions?
Do you need a file in the courts for a personal directive?
No, a personal directive is a private document that an individual creates when they're competent to appoint someone called an agent to make personal decisions on their behalf if the individual, the maker, is what they're called in the legislation, is no longer capable of making those decisions. So that document, it's not a regulated form, though there are sample forms provided by our office that you can use to complete a personal directive. And once a personal directive is completed, it doesn't have to be filed with the court to be effective or anything of that nature. So the court system doesn't really have anything to do with a personal directive document.
How long does this process take?
Generally speaking, once the application documents are complete in our office, and sometimes that can take quite a while. We've had some files that have gone back and forth between applicants and our office, or our office and law offices, to get the application documents to the point where we feel they won't be rejected for filing by the court. Once they come into our office, then we start the notice process. The notice period is approximately a month. So once we send out notice, everyone kind of gets about a month to think about it, to ask questions, to determine if they should submit a request for hearing or anything of that nature. Once that notice period is done, then we will complete a review officer report and submit the application. Well, part of that is then that visit to the adult has to happen. Sometimes that can take more time or less depending on where the adult is located, because again, we will visit them wherever they are located in the province. So generally speaking, the processing time within our office is about 2 months. And then once we file it with the court, we have no idea how long the courts are taking. Because again, we file applications in all the courthouses in Alberta, and all of them have different wait times and schedules in terms of how long that takes.
Is there a cost if you request a review of the court order?
So if an outside individual wants the review to be done, right, then really the process, if it is, I guess, non-contested, a review, because there's already a court application, there's a court filing fee of $50 for the review application itself. Now, I'm not really going to discuss a situation where an outside or interested party wants a trustee or guardian to do a review and that guardian doesn't want to do the review, for example, because that could be a whole court process and court orders directing them to do this, that, or the other thing type of thing, right? But the court filing fee where there's already a court file is $50.
Beautiful. What if the guardian or trustee begins to lose capacity themselves? How is this reviewed?
Okay. there is provision in the legislation that if a guardian or trustee, particularly if a trusteeship or guardianship order is granted for an appointed trustee or guardian already, then there's provision in the legislation for an alternate to take over and so on. As well, if a enduring power of attorney or personal directive comes into force for a existing trustee and guardian, again, there's provision in the legislation for alternates to take over and for potentially both the public guardian's office and the public trustee's office to be notified of that situation so that we can monitor to make sure that someone is in place who is competent, who can make decisions on behalf of the adult. So the legislation does provide for those situations.
Is it really proper for the social worker to witness the personal directive?
As far as I know, proper is a kind of a funny word, right? The legislation, the personal directives legislation sets out who definitively can to be a witness to a personal directive. I believe it's, you can't have the agent or the agent's spouse or the maker's spouse, so there's very specific categories. So assuming the social worker is not within any of those prohibited categories, then there's nothing legally that would prohibit a social worker from witnessing that document. Now, whether it's proper for the individual to do it certainly would depend on the circumstances of the situation. Though certainly, to a certain extent, social workers are one of our allies in promoting personal directives, the creation of personal directives, and enduring powers of attorneys for individuals who might be in care or might be in those situations where a potential loss of capacity might occur, but at the time, the people are competent, so they have the ability to make those documents. So social workers often are our allies in saying, this is a good idea. If you don't want a guardianship and trusteeship and that whole process to have to happen for your loved ones, potentially you should think about making these documents yourself and save all that trouble.
What happens if the individual no longer wants their appointed trustee or guardian to act as their guardian or trustee?
Okay. So certainly an adult has the right to request a review of their guardianship and trusteeship. So, they can request review for any number of reasons. It could be that they feel that they're competent enough to make their own decisions, and if they have some kind of medical evidence to back that up, they can do that. Now, if they don't feel that they can make their own decisions, they just don't like their trustee and guardian. Now, again, the court, an adult can make that application for a review to say, I don't want my mom or my dad, I want my brother, my sister, my neighbor, whoever to do it. And it would be up to the court to determine both if the individuals who are currently trustees and guardians are appropriate, and on the other hand, if the proposed individuals are also appropriate, right? And again, I always think that's kind of a fluid situation, only because to be honest, for an adult, having someone else control decision-making in their lives, both personal and financial, can sometimes be not the most ideal situation. We certainly have a lot of clients with both the public trustee and the public guardian who probably aren't super happy that we're their trustee and guardian. But it's really for the court to determine if, a private guardian or a private trustee is making appropriate decisions. So they may look at some of the decisions being made to see if it's appropriate. It's not a simple process to swap out trustees and guardians. Again, it does involve that court review. But again, it can be reviewed. Doesn't mean that any change will be made, but it can be reviewed for sure.
What happens if the adult doesn't have a regular doctor or we don't know who the doctor is?
Yeah, that's unfortunately one of the more difficult situations in terms of guardianship and trusteeship. So even if you suspect that someone has diminished capacity, if you don't really have a way of getting the capacity assessment report completed, then that's a pretty big roadblock in terms of obtaining a trusteeship and guardianship order. As I said before, it is possible, though it doesn't happen very often, for the court to make that determination without a capacity assessment report. But normally, what we would say is that that's where potentially the designated capacity assessors come in. So those are people who you can get you can contact our office and we can provide you with names of people who have been designated as capacity assessors. And some of their services do include coming out to an individual who doesn't have a regular doctor. Or certainly we've heard of those situations where people haven't been to the doctor in many, many years, so they literally have no doctor, to come out and do an assessment of them. As I said previously, you should always discuss what the cost is and so on. But that does exist. Unfortunately, that continues to be kind of a stumbling point in the whole process, right? I think you really can't get away from that because, of course, when you're talking capacity, that's still all determined medically. So you got to have a doctor, a psychologist. You got to have someone. It can't be just you or I making that determination, even if sometimes it's quite obvious.
And the last question is just, where can people email to access this presentation?
Let's see if I know that question. It says you can go to csslearningseries.ca for information about this session and for information about other sessions. And as that was the last question, I thank everyone for joining us this afternoon for our session about completing an AGTA application. I hope you found the information useful. As I said, if you have any questions, please contact one of the regional offices. This webcast is part of the Government Alberta's Community and Social Services Learning Series, which will be running around the same time each month through June 2017. The series covers topics from the Office of the Public Guardian and Trustee, and also covers topics from other agencies like the Alberta Brain Injury Initiative, the Fetal Alcohol Spectrum Disorder, and Employment First Initiative. The application has been recorded and is available online. And again, if you go to that website, you can probably find the link and it'll exist forever. Thank you very much.